The topic is the Civil Rights Act of 1964 and the Tennessee Human Rights Commission. And we're talking to the Executive Director of the Tennessee Human Rights Commission, Ms. Amber Gooden. And of course, Ms. Gooden, before we had our break, I think I sort of interrupted you when you were explaining some of the exceptions in reference to the difference between the federal statute and statutes of various states. Let's continue. Let's give it up to continue that.
As I was saying before the break, that under Tennessee law, we begin looking into or investigating complaints when an employer has 8 or more employees, as opposed to on the federal side where it is 15. Then that allows us really to deal with, when you think about it, more smaller businesses as they're concerned. On the housing side, for instance, under housing discrimination, we can also investigate, and people can file complaints as it relates to commercial real estate, not just residential real estate. Another difference on the federal side is that under federal law, a landlord or someone would have to own 4 or more properties. Under Tennessee law, all is required is one property and so forth. And I find that really, especially on the housing side, that people really don't understand and really know many times what their rights are and how they are being discriminated and victimized.
Well, now, what are some of the rights in terms of housing that you recognize that, and some of the violations that generally come across your desk at the Tennessee Human Rights Commission?
One of the biggest areas and complaints that we find is we're educating more, people are finding out, and that is in the discrimination of what is called familial status. Familial status is discrimination against one who has children. People are still, many times we find that people still believe that someone can advertise or say no children and so forth, when actually, in fact, that is against the law. Unless an apartment complex or a residential facility has sought a designation from Medicare as being, you know, senior living and so forth, and especially for seniors, it is unlawful to turn someone away because they have children.
I mean, now what would be the rationale for a landlord not to accept children? I mean,
many times people believe and think that because one has children, that they will not be as careful with their property and will tear it up. So let's take a scenario. If you were coming to, let's say I were coming to rent from you, and I brought my 2 or 3 children with me, and I saw that there was an ad in the paper for an apartment. For you to tell me that it was not available for rent because in the back of your mind you're saying, I don't want those kids tearing them up. And then the very next person comes and they don't have children and you rent to that. If I found that out or suspected that that was the case, and I go and file a complaint, then we would initiate an investigation and begin looking into the records of that landlord, what kind of ads they placed, might even send in what we call testers. Testers are people that are approved by HUD, that have been through training and so forth, to mirror the discriminatory situation that we're looking into. They write up a report, it's unbiased. We usually go through a third party to do this. They're not people on our payroll. And through that then would confront then the landlord about the findings and so forth, and attempt then to get some type of relief for the complainant. What many people don't understand many times is that, especially in smaller rural areas where affordable housing is so limited, when one does this, it might make the difference in somebody having to live in a shelter because they're seeing that nothing is available for them to rent. It is, however, lawful for that landlord to ask for an application from everybody to check references. A landlord does not have to rent to somebody who has a history then of tearing up the property, of leaving without paying and so forth. So you see how we're getting at that. What it is unlawful is just to decide because the way somebody looks, their ethnic background, or the fact again that they have children, or maybe even have a disability.
Those blatant,
right, exactly. Under the law, it looks at all of those things.
Now, does the Tennessee Human Rights Commission also enforce the Disability Act of
yes, we do.
Talk about that, because I think that's a real
well, and under housing, we do as well, and part of that covers the fact that, for instance, if someone has a disability and they need what is called an accommodation, a reasonable accommodation, for instance, maybe there is a ramp that is needed, or to make a chair railing, you know, in the bathroom and so forth, the landlord within reason has to make those accommodations. Let's say for ease of the person who's disabled, if let's say they were living on the top floor, and we actually had a case like this, where a couple who had a disabled child lived on the top floor of an apartment, wanted to move down to the bottom floor. The landlord wanted to charge that person a fee, a transfer fee to do that. Under when you have a disability, you are exempt from that, and so forth.
But they can charge a transfer fee under ordinary circumstances.
Under ordinary circumstances, right? If there are no other issues and so forth. Again, you cannot, for instance, bar someone from having, let's say, a dog or a pet if it is used to help someone with a disability and so forth. Under
a CNI dog, for example, would be permissible even in an apartment that said no pets allowed.
Exactly.
And so in a real sense, the Tennessee Human Rights Commission plays a very, very important role.
Extremely, extremely. Because we are a substantial equivalence agency, we in a sense are very similar to that to EEOC and to HUD, Department of Urban Housing and Development. In fact, if one was to go to EEOC's website, they would see the Tennessee Human Rights Commission referred on that as well. So it allows people that you can either go to EEOC or you can come to us to file a complaint, but also know this too, especially when dealing with more with Tennessee law, that we have and we can the jurisdiction to investigate more things as it applies to Tennessee law.
You know, when we come back, and I think we're making preparations in a minute or two dealing with for our second commercial break. But when we come back, I want you to think in terms of the complaints that you have to sort of give us a laundry list of most complaints and on down and et cetera, and what people might do in terms of objecting to these complaints through your particular office. And I think that will give us an opportunity not only, and of course, as we said, since this is the Civil Rights Act of 1964, if you've got some additional information to tie in the Tennessee Human Rights Commission with that Act of 1964, outside of that act being really the parent in a real sense of your organization, we certainly would, you know, we'd appreciate that.
Right.
And so we'll do that when we come back during the second segment. But now I think we've had some good information, and this is essentially what we wanted to do, because I think that over the next few weeks with these shows, folks will have a better understanding of the Civil Rights Act of 1964. And of course, we'll be back with our audience following this very, very short commercial break. We're talking to Miss Amber